prosecutor might get the message that you're trying to deliver. And the other is that what I used to do, what I did in my cases, some of my cases, I put the name of the prosecutor in the opinion, in the text of the opinion, so that anybody reading the opinion would know that this particular prosecutor was using prosecutorial misconduct to try to get a conviction. That's very important to do, in my opinion, because a number of prosecutors want to become a judge someday. And when they attempt to become a judge, the person doing the evaluation looks at some of their cases that they were on, and they see their name in the opinion with prosecutorial misconduct. That diminishes that prosecutor's chance of becoming a judge. So no one wants to select somebody that's like excluding people because of their race. I put their names in the opinion, in that People versus Spain. Can I go back to that for a minute? I'll tell you something interesting about that. Well, after the Illinois Supreme Court reversed me in that case, just coincidence, just random selection, I got 3 other cases involving the same question. But now the Illinois Supreme Court had reversed me and said I was wrong for what I did, so I couldn't again reverse this conviction while the Illinois Supreme Court, this was before the U.S. Supreme Court case came down. So I get these cases, and I was upset.
Right.
So what I did was, I says, all right, I have to follow the Illinois Supreme Court, but I'm putting the names of the prosecutors in the opinion, and I put their names in there.
Yeah.
And I also said that from now on, whenever a prosecutor is accused of excluding people from the jury by peremptory challenge simply because of their race, that the appellate court should no longer file unpublished opinions, that the opinion has to be published so that the public will know who these prosecutors are. That's another thing that could be done, which I did. But the other judges on the appellate court didn't follow that anyway.
Yeah.
So you understand that in the appellate court, they have unpublished opinions and published opinions. The unpublished opinions are opinions where, I'm not saying this is done, but if you want to sweep something under the rug, you just make the opinion unpublished. You decide the case and you say this is going to be an unpublished opinion, which means it's not published, nobody knows it, nobody could see it, okay?
Right.
So I felt that one of the ways that I could get back at these prosecutors was to say from now on, all opinions where their names come up have to be published so that the public could see who they are, and there's a record of it.
Right.
And that's another thing that could be done in any type of prosecutorial misconduct. Put the prosecutors' names in the opinions and publish the opinions. Don't make them unpublished. Those are things that could be done. And the harmless error rule, I never liked that too much. I wrote an opinion dealing with harmless error in a sense, where there was lost evidence. I can't think of the name of the case right now. But I reversed the conviction where prosecutors had lost, they claimed that they lost evidence that was in their possession prior to trial. And then when the defendant wants it produced, the prosecutor says, well, it's lost. Well, in the opinion, I think they talked about it in the article, that's the one where I said that there's a black hole in the evidence room or something.
Yes. Yeah.
Okay, what's the name of that case? Some notes here. People versus Hall is the name of the case. In People versus Hall, there was some there was witnesses interview statements that the police had, and the defendant wanted to use those interview statements, and the prosecutor said we lost it. Well, look, the state and the prosecutors have to understand the responsibility that they have for maintaining evidence in their possession prior to trial. There should be no, unless there is a fire or a flood or an explosion in the evidence room, there's no reasonable excuse for losing evidence by the state.
Right.
There isn't any. There really isn't. They've got a responsibility. They know they have to maintain this evidence. To come in and say it's lost, there's no reasonable excuse. Like I say, unless there was an explosion, fire, or a flood in the evidence room, they have no excuse. So I wrote a dissent in that case, in People versus Hall, and I wanted to reverse the conviction. This is a good example of what I'm talking about. The two other judges on the panel, they says, well, you shouldn't lose evidence, prosecutors shouldn't lose evidence, but they affirmed the conviction. Accomplishes nothing.
Right.
So I wrote a dissenting opinion, and I said this case really should be reversed because, as I said, it looks like there's a black hole in the evidence room where the stuff goes in there and suddenly they can't find it. See, people have to understand an accused person doesn't have the resources that the state has when they're trying to prosecute him. So the state has unlimited resources, and they have all the advantages when they try to prosecute an accused. If you give the state an added advantage by losing evidence that might help the accused or defendant, you're just not playing on a level playing field any longer, and it's wrong. Now, maybe you might say, well, in that particular case or in a particular case, it looks like the person did it anyway. Okay. But what about the next case where it's a close case?
Right.
And the prosecutors do the same thing. Unless you are the accused, okay, you don't realize how important it is to make statements like I was making in my opinions. It's very important.
So what were some of the challenges you or any other judge may face when working with prosecutors?
Challenges?
If there are any.
I'm not sure what you mean by challenges. You mean as a judge, when I was a judge?
Yeah, or any frustrations that you may have faced when working with them.
Well, I wanted to make sure that the prosecutors were conducting the trial where they were seeking justice and not just a conviction. And I wanted to make sure that the prosecutors didn't commit any, what I considered prosecutorial misconduct, that it wasn't repeated. And I recall that when I was on the appellate court, when I would hear oral arguments, if I was hearing oral arguments in a case involving prosecutorial misconduct or stuff that was what I felt was not correct by the prosecutors or by the state, I would tell the attorney during the oral argument, the attorney representing the state, that to make sure when they go back to their office that they tell the state's attorney in their office that this practice has to stop. And if it was a pattern, I would let them know that, in my opinion, this was a pattern and not just an isolated case. And I would try to make sure that they understood that we weren't going to put up with it any longer. And that we rightfully shouldn't put up with it any longer.
So, as a judge, did you ever get the sense that there was a certain culture that came about as being like a prosecutor?
A culture.
Yeah, like that they, shared similar beliefs and did certain actions that would promote injustice?
Well, I mentioned the fact that I felt that there were too many prosecutors that felt that they wanted to get a conviction, that their purpose was a conviction rather than justice. I think that's important. And you see, there's another thing that's not readily apparent, unless you're familiar with the system. Many prosecutors become judges.
Mm-hmm.
So the history and the experiences that they bring with them when they're deciding the case is their own experiences as a prosecutor.
Mm-hmm.
And if you're an accused, sometimes that could work to your disadvantage because they draw back on their own experiences as a prosecutor and the mindset they might have had about the importance of getting a conviction. Sometimes that affects their decision as a judge.
Mm-hmm.
Because when you're a judge, you cannot divorce your life experiences
Mm-hmm.
from the things that cause you to make a judgment one way or the other. You can state that you do, but the reality is you don't.
Mm-hmm.
Okay, so diversification on the court is very important, so that you don't have judges that all have this similar experiences and backgrounds. So that's why it's very important that there be a diverse judiciary.
Mm-hmm.
And that would help fairness and justice, in my opinion.
You said that judges can't divorce their life experiences from their experiences on the court, while in court. Do you have any specific sort of experiences with your life that you feel informed your decisions?
Well, in my growing up, there was never any prejudices or stuff like that going on in my family. And from myself as a youth, or even as I got older, we always treated people the way they should be treated, regardless of what they looked like or who they were, and stuff like that, or what they believed. Just my upbringing, I guess. Just my upbringing, I would say.
So what are some checks and balances that exist within the system that could help to hold prosecutors accountable for their actions?
Run that by me again.
What checks and balances exist within the system that could help hold prosecutors accountable for their actions?
Checks and balances?
Mm-hmm.
What do you mean by checks and balances?
Any reviews or any anything that's part of the system really that could help hold them accountable.
For prosecutorial misconduct?
Or just for their actions in general.
Well, like I said, that you want to put their opinion, you want to put their names in the opinions if it's gross prosecutorial misconduct.
Mm-hmm.
want to make sure the opinions are published. And the trial court